How to prepare for court. Now that you have the date for your small claims trial, it's time to prepare for court. Here are 4 tips for both plaintiffs and defendants on preparing for court. First, gather all of your evidence. Evidence is what you use to prove to the court what happened. Evidence can be documents, like bills, invoices, canceled checks, cash receipts, or letters. Photographs and objects are also evidence. And evidence can be the statements of witnesses who know firsthand what happened. Ask them to come to the trial and tell them in advance the time and date. You can ask the court to order a witness to show up for the trial. The court will issue a legal paper called a summons, which you will have to pay for. Second, rehearse what you will say at trial. It often helps to rehearse several times and to rehearse in front of others. Third, in your statement to the court, get right to the point. In your very first sentence, tell the court what happened and what you want the court to do. Then fill in the details, including the evidence you brought with you. Your remarks should be less than 10 minutes. Finally, be on time and dress properly for trial. Business casual is appropriate dress for court. Sloppy or skimpy clothing is not. Try not to schedule such events as picking up children after the trial. There are many reasons why your case might not start on time or take longer than you expected. Make sure you know where the courthouse is. Leave plenty of time to get there early and to find parking. On your trial day, find the right courtroom by looking at the printed list of the day's cases posted in the clerk's office. Your trial will be heard by an official of the court, either the clerk magistrate or the assistant clerk magistrate. Before trial, you may be asked if you want to try mediating the case. Mediation is when both sides agree to let an experienced person help you reach an agreement without going to trial. Mediation is free, and your discussions with the mediator are private. The mediator will not disclose what was said. If you cannot reach an agreement, you will then return to the courtroom for the trial. In the courtroom, there might be many people with cases scheduled to be heard at the same time. Listen for your name and answer present or here when it is called. Make sure you have everything you need to explain what happened. You could lose your case if you are unprepared. The plaintiff goes first, then the defendant. The clerk magistrate may ask some questions to the plaintiff or to the defendant, or both. The plaintiff and the defendant also have a chance to ask each other questions. Wait your turn to speak. Keep your tone polite. Be respectful to the court and to the other people in your case. The clerk magistrate may make a decision at the end of the case. Or the clerk magistrate may take the case under advisement. That means you will receive a written decision in the mail in about 10 days.